Hello and good morning, everybody. I'd like to kick off by extending a very warm welcome to all the business owners and entrepreneurs who have joined us this morning. This is the first, or the very first, in a monthly series of business webinars that Business Accounting Network will be hosting together with our alliance partners. And our alliance partners specialize in other areas of business expertise, such as commercial law, labor law, business valuations, business advisory, and that's just to name a few. So as business owners, irrespective of how small some of our businesses might be, we are all already quite overwhelmed just by the sheer volume of laws and regulations that govern our everyday lives. And we still need to try and find time to run our business and drive our business. And we all have to deal shortly with the change in the VAT rate from 14 to 15% by the end of this month. And of course, we've just had sugar tax now introduced that comes into effect for beverage manufacturers on the 1st of next month. And now we have POPI, which will come into effect more or less in 12 to 16 months. But there's a lot that business owners need to prepare for POPI before they really off actually applying it. So our presenter today, I'd like to introduce you to Robyn Hay of Robyn Hay Attorneys. Robyn is an admitted attorney to the High Court and a strategic brand alliance partner. Business Accounting Network accountants work very, very closely with Robyn Hay Attorneys Incorporated. Robyn specializes in commercial law, with particular emphasis on business rescue and liquidations, commercial litigations, and specifically also commercial contracts. Anything from shareholders agreements for companies, shareholders association agreements for members of close corporations, buy and sell agreements, and so much more. So I'd like to hand you over to Robyn Hay, who will be presenting this morning's session for an hour, which is the POPI Act. Very welcome, Robyn.
Hi, Monique. Hello, everybody. It's nice to have you all here today. Yes, as I was saying, good morning, everyone. So just if you don't know why you've logged into a POPI presentation, which is essentially a presentation on the Protection of Personal Information Act. Now, lawyers like to create mass panic amongst lay people by telling you that all sorts of horrific things are going to happen if you don't comply with legislation. So my reason for being here today is to demystify POPI and to break it down into some understandable and manageable chunks, with the idea of, by the end of this, you'll be in a position to at least know what your way forward is, the timeline you've got, as well as a little bit about the Act itself, so that when you're at the braai this weekend, you can be the cleverest person around the braai. So just to start, just a little bit about myself, which for most lawyers is our favorite topic. But for me, I've been a commercial attorney for 15 years. I trained at one of the big firms. And I am absolutely passionate about small business. I feel extremely strongly that small business is the future of South Africa, and it is really the backbone of what is going. Sorry, I'm just trying to get rid of this little thing because it's covering the. The backbone of business in South Africa and the real future of our economy. So I own a small business as well, a small business in terms of the SME definitions. And I understand how complicated compliance is. And one of the things that I get from business owners time and time again is, how the hell am I supposed to run a business when I spend half my life panicking about random legislation and I don't know what I don't know? So my role is really to make sure that businesses are future-proofed, that they're both able to continue to operate, and that they're able to withstand changes in legislation and any kind of additional changes that may be happening within the environment. So now what you've probably heard about this POPI. And you're probably rolling your eyes, much like the woman in the picture, and going, what the hell does this new and exciting piece of legislation have to do with me? Well, POPI stands for the Protection of Personal Information Act. And what I've done there on this slide, which, as Shane said, you'll be getting at the end of this presentation, is I've included links to the government sites that has got the current version of the Act as well as the draft regulation. So you can go and read it yourself. If you can't sleep and you're out of Horlicks, you may well want to read this legislation. Alternatively, you can pay someone to read it for you, which is normally what, to be honest, the role of lawyers is. So only at this point, there are only very limited and not terribly important sections which have commenced. So in other words, only the following sections are in operation at the moment. So that's the definition section, the creation of a regulator, it's called an information regulator, and the power of the minister and the regulator to make regulations, as well as the procedure for making regulations. So when is this POPI thing going to happen? We get that a lot. So I'm not going to lie to you, it is a bit of a mystery. The first thing is the information regulator has to be operational. So currently the offices have been set up, they're busy staffing the offices. And at the moment it looks like the regulator is going to be fully functional by the end of 2018 or the beginning of 2019. From then, the president will then choose a commencement date and announce it broadly in the well-read government gazette. And after a grace period of 1 year from the commencement date, you need to be fully compliant. So realistically, and this is not a reason to hop off the webinar, but realistically, you're only going to have to be fully compliant at the beginning of 2019, at the mid-2019 or the beginning of 2020. So why are we worrying with this now? Well, some businesses are more at risk than others. So if you run a business where there's high levels of marketing, direct marketing, where you're online a lot, where you're offering IT services or support services, where you have an online or cloud-based platform, where you deal with high numbers of clients, it's going to take time to get your compliance right. And compliance is costly. You know, you're going to need to take some time out to follow the steps that I'm going to go through at the end to make sure that you can be compliant. So although a year sounds like a terribly long time, or 18 months, most of you know that although there are 12 months of a year, essentially you are only fully operational for 10 or 11 of them if you look at all the leave and holidays and cyclical things that happen in your business. You also need to make sure that you've got best practices in place by the time this legislation comes into effect. And if you don't have best practices in place and you're not compliant, there are significant penalties and significant risks to you if you get caught. So I'm a big fan of not rushing everything at the last minute. It's easier to become compliant if you've got a process in place and if you've budgeted for it and you've given yourself time to work with your advisors to make sure that everything is in order. So the regulations are also not expected to change terribly much, so there's not going to be a duplication of costs. And many of your businesses may already be impacted by the GDPR regulations. So the GDPR regulations are part of the European Union's legislation, and it applies to everyone who's either established in the European Union or who offers goods and services in the European Union or whose clients are in the European Union. So there may well be a situation where you already have to start complying with data protection, and getting your ducks in a row now is actually maybe even a little bit too late with regards to GDPR. You actually need to get your act together. So what is the point of POPI? So the point of POPI is really to protect your personal information. And William O. Douglas, who was a jurist and a politician in the US in the late 19th century and up to the 1980s, had this to say, and this is over 100 years ago, which is really interesting. And it says, Big Brother, in the form of an increasingly powerful government and in an increasingly powerful private sector, will pile the records high with reasons why privacy should give way to national security, to law and order, to efficiency of operation, to scientific advancement, and the like. And that is the case. If you think about it, there have been more and more carve-outs with regards to our personal information and our private information over the last couple of years, under the guise of, keeping information because of potential terrorist activities, having to have health and safety information for any kind of labor purposes, getting information in for BE and employment equity plans and other purposes. So they all have noble purposes. But the truth is, who is monitoring those people who have access to all our information? And there's been a massive move globally, not just in South Africa, to make sure that your personal information is not collected for purposes that you haven't consented for it to be collected. So the global village means that information gathered for one purpose can be easily used for another. And the right to privacy is actually enshrined in our constitution. So if you have a look at the reasons for POPI, what's called the preamble to the Act, says essentially that we want to promote the protection of personal information that's processed by public or private bodies, and that there are minimum codes of conduct and requirements for processing of personal information, and that the rights that we have with regards to unsolicited electronic communications and automated decision-making is actually regulated. And then also that your information stays within the borders of your country, because the internet makes it so easy to get information into other countries where there are other regulations and other reasons for that you can use personal information for. So essentially, you don't want your information, or you don't necessarily want your personal information being sent into another country. Okay, so that's the background. Now, I just want to start with a couple of very important definitions. And I'm not going to go through all of them in great detail, but just to start, the definition of personal information is extremely broad. It's information relating to essentially the elements that are set out in the Bill of Rights, being information relating to race, gender, sex, pregnancy, color, sexual orientation, mental health, well-being, disability, a whole range of them. So it's personal information that relate to the rights that have been entrenched in the Constitution. It also relates to information on your education, medical, financial, criminal, or employment history. Any identifying number, symbol, email address, physical address, telephone number, location information, so that will include GPS coordinates, online identifier, which is your usernames, and any other particular assignment. So anything that, if you trace back, you will get to Robyn Hay. So where you've got a bank account and they say, have you forgot your password? Send me your email. And through that email, they're then able to determine that you are one of their customers. That is an identifier. That brings you back to who the person is. Then also biometric information, and then things about your personal views and opinions. So if you're doing a survey and you're asking people to give their views and opinions, that information is personal information. It also applies to correspondence and your name. So essentially, it is anything that would, within the definition of this act, would be considered personal or private, and also anything within the definition of this act that you would be able to use to identify yourself. Then there's a concept of de-identification, which is really where you can strip out the information so that you can't take it back to the individual. So, for example, if you're collecting data for legal compliance purposes, so if you're like finding out how many people of color are in your organization, how many people with disabilities, you can strip that information out so that you can't tie my ethnicity, for example, to my name, and that's called the de-identification. Then your data subject is essentially the person whose personal information you are processing. You've got a responsible party, which is last on the list, and an operator. So the responsible party is the public or private body which determines the purpose of and the processing of the information. So that will be, in my case, it'll be my law firm is a responsible party, your business is a responsible party, a bank is a responsible party. So anyone to whom this personal information is, or by whom this personal information is being collected and processed. And then your operator is a third person that processes information on behalf of a responsible party. So, for example, if you outsource your marketing and you send your client database to an outsourced marketing company, they are considered an operator with regard to you as their client, but they're also considered a responsible party in their own capacity. And then lastly, the very broad definition of processing. So it's both the collection of and storage and updating of personal information, the dissemination of it, so in other words, the sending of it out, and also the merging of it. So if you've got names on the one hand and email addresses on the other hand, if you merge that information, that's also considered processing. So what do you have to do to be compliant? So I don't know whether any of you have already heard of the 8 conditions for POPI compliance. We in the legal profession have started to refer to them as the Hateful 8, because these are the 8 conditions that we're going to have to be able to assist our clients in complying with, so that they are actually complying with POPI in a way that is practical and useful for their business. So as you see, I've just listed them there, and I'm just going to go through them one at a time. Now, I just want to pause at this point to say, what I'm doing today is giving you an overview of the Act. The Act is vast. It is complicated and it is vast. Please don't assume that having attended one POPI presentation and one seminar and one very quick description of what's going on, that you have a perfect understanding of the Act as it applies to you. This is not legal advice so much as an opportunity for you to be informed. So you do need to make sure that you understand how these particular conditions apply to your particular business. So the 8 conditions, or the Hateful 8, are the minimal conditions to which any organization that processes personal information is required to adhere to, all right, in order to be compliant with POPI. Oh, wait one moment, while my computer has decided the Hateful 8 is the end of it. There we go. So what I've done for you is I've given you the condition and then the section of the Act that it applies to. I've not rewritten the section of the Act because I don't want you to be bleeding from your eyes on a Friday morning. And unless you're a lawyer, reading an Act is the most boring thing in the world. In fact, even as a lawyer, I can't say that I wake up enthralled with the idea of reading legislation every morning. So the responsible person, which for your purposes is you as the business, needs to be accountable. So the first condition for complying with POPI is accountability. The first thing you need to do is identify and appoint an information officer. The information officer is the POPI boss. That is the person who is going to determine the purpose of and means of processing personal information. They have to identify what personal information is being processed and why that personal information needs to be processed. So, for example, if you have a client onboarding form, so you get a new client and you need to get all their details so that you can invoice them, that then means that you are collecting personal information, and the purpose of collecting that personal information is so that you can invoice them. So that information officer has to decide whether that purpose is fair and reasonable and complies with the Act, and what information is actually being collected. So for example, when I issue an invoice, I don't need to know how many children that person has. So if I start asking for information regarding dependents, I am overreaching with regards to the information that I'm required, and then the information officer in my firm will have to reassess whether that information, for example, if it were on my client onboarding form, which it isn't, is necessary for the purposes of why is necessary for the purpose for which we are actually collecting the information. And there's the processing limitation. So your personal information must be processed lawfully and in a reasonable manner that doesn't infringe the privacy of the data subject. So remember, the data subject is the individual, or in some cases, the business that is providing the information. So if you have because I think what's important to understand is that a person, in terms of the Act, is both a natural person, in other words, an individual, and a juristic person, which is a business. So reasonableness is actually quite a tricky concept. And if you want to know if something's written by a lawyer, look for the word reasonable. Because reasonable means what is objectively reasonable in the circumstances. And here you've got some guidelines. So you need to collect the minimal amount of information required. So it's not, if you have going back to the client onboarding form, or your account application, or new client information, or signing terms and conditions, that can't be a catch-all for collecting every single piece of marketing material you could possibly ever need, getting all additional demographics for some project that you're doing. If you say to the client that the purpose for collecting this information is so that we can onboard you as a client, then all the information that you request must be the minimal amount that you need to process. A client must also consent, and that needs to be voluntary consent. It can't be consent that if they don't say anything, that there's a negative obligation on them to actually say, no, I don't consent, rather than there must be an opportunity for them to say I do consent, rather than an opportunity to say I don't consent. So an opt-in process. You also need to explicitly explain to clients why you're collecting their information. So you've got to be able to say to them, I cannot issue you an invoice because the VAT Act requires this information, and if you don't give me that information, I can't invoice you, and if I can't invoice you, I can't do business with you. And it's got to be informed consent. You've got to be able to justify the information, and the data subject has to be given an opportunity to object. And wherever possible, you need to obtain the information directly from the data subject. And the overarching principle is that you can only use that information for the purpose expressly explained to the data subject. So as you're sitting here with your heart pounding in your chest, which I have to tell you that even as an attorney, I look at this and I think, well, this is going to require a significant overhaul of my terms and conditions and the manner in which we collect information on our clients, which is a process we've just started putting in place ourselves. It does require you to re-look at your terms and conditions, to re-look at your client onboarding documents, and to make sure that in those terms and conditions and those onboarding documents, you are very clear in why you are collecting this information. And we're going to come back to marketing later on in the webinar, but you'll see that the days of this may possibly be used for maybe talking to you every now and then in tiny, tiny print at the bottom of the page is no longer acceptable. Then you've got a purpose specification. So there are three main elements to this. Your purpose specification is essentially you've got to say that you are collecting for a specific purpose, that the data subject must be aware of the purpose for which you are collecting, and in addition, that you are only going to retain the records for the minimum amount of time that you have to retain them. So it's not going to be retaining records forever and ever, amen. It's actually going to be retaining records for the minimum amount of time. Now, sometimes you have to retain records after a client leaves you because the Companies Act or other legislation requires you to keep the records for a longer period of time. For example, for us, we have to keep our records in terms of the Law Society rules for another 5 years, before we can destroy them, because a client's got the right to come back and ask us for that information. So that's one of the things that you need to consider is who regulates your personal information and the retention of records, and how do you go about making sure that you keep it for the same minimum amount of time. I hope that makes sense. If there are any concerns, just let me know. Okay, so give me a second, sorry. There's also a concept called the further processing limitation. And the further processing limitation is that if you're going to collect information for a specific purpose, and then you're going to do something else with it, the further processing of personal information must be compatible with the reasons why it was initially collected. So you need to consider the relationship between the initial reason for collection and the reason for further processing. So for example, if you are collecting information on your suppliers, you may be then required to, for example, retain their BE status or retain some of the ownership of those companies, strip out that information so that you're able to make sure that you comply with BE requirements, as an example. Now, that is important because what you're essentially doing there is you are essentially saying that further processing is something that's required by law, and as a result, because it is required by law, we have to actually keep it. We can't just, we have to do this further processing. We have to strip out that information. We don't have any choice in that regard. Then you also have to consider the nature of the information. So is it something that directly deals with the identity of the party, or is it something that can be stripped out so it can be separated from the identity of the party itself? Then the consequences of further processing, will it impact the data subject? Will the data subject struggle with something going forward, or have the privacy rights further infringed by the further processing? And then how was the information collected? Was it collected in a way where proper and informed consent for all possible future purposes was explained to the data subject? And then also, what is the contractual relationship? So again, your terms and conditions, your client onboarding forms, your POPI policies are going to be absolutely essential. And your best practices have to be developed because you're going to need to train your staff. So if you are in sales, you're going to need to train your staff to be able to explain why information is being collected. And that staff have to be extremely careful with the information that they do collect. So if they are out in the field with a tablet or a cell phone, and they're collecting information through an app, they can't leave that tablet or cell phone lying around password protected where other people can get hold of that information, because they need to understand that if there's any kind of breach down the line, your business is on the hook. And this I find very interesting. So one of the things, if you're going to get information, it's got to be of a good quality. So the information has to be complete, accurate, not misleading, and up to date. You also have to maintain the integrity of the information. So you have to correct it or make sure that it is corrected from time to time. And you can't have information on your databases or information on a client that is just completely wrong. And when you are updating personal information, you need to bear in mind, again, the original purpose of collecting that personal information. And I think this is really your guiding principle, and that is the principle of openness. You need to make sure that your clients, your data subjects, are aware of the information that's being collected, and if it's not being collected from them, where it was collected from. The name and address of the responsible party, so that's your business, they need to know who is the responsible party, who is the person collecting or processing this information. Why is this information being collected? And is the supply of information voluntary or mandatory? So for example, what if you are onboarding clients and you want to understand what LSM group is buying from you, a voluntary piece of information would be possibly what is your household income. But if you are collecting information, for example, purposes of getting a tax invoice put together, there's certain mandatory information we need. You can't produce an invoice under other circumstances. The consequences of a failure to provide the information needs to be explained. So for example, if we don't know what your turnover is, your household income is, we're unable to properly market to you, that the data subject may decide, well, I don't need that marketing. But if we don't get this information, we can't invoice you. And if we can't invoice you, we can't act for you. You know, that's something that the data subject may or may not decide is very important. Then you've got to look at the law authorizing or requiring the collection of information. I know I keep referring to an invoice, but I think that's something all of us have to send out. And there, for example, you're dealing with all kinds of tax legislation, specifically the VAT Act, and what must be on a VAT invoice if you are VAT registered. You also need to let the client know if you're going to transfer the information to a third country or an international organization, and what level of protection is going to be afforded to that information, and then any further relevant information. So I think if you are wondering where to start, you need to start by being completely honest with your clients about what information you're getting from them and why you're getting that information from them. And for me, this is really, although it's quite far down the list of the Hateful Eight, it is really for me the guiding principle. So if you look at drafting your documentation in a way that's easy to understand, where you've got, for example, a block on the front of your contract that says, we collect the following information for these reasons, you can't go wrong. That kind of information, provided it is lawful, you really can't go wrong with that. You have to be transparent and you have to be fair in processing the personal information. And you have to give your data subject an opportunity to object to the processing of their information, and they have to be informed of this right. So if, for example, they give you the information on turnover, but then they decide they don't want to give it to you anymore, they have to be given a right to object. And the provisions of POPI, which is the Promotion of Access to Information Act, overlap quite strongly with with POPI, the Protection of Personal Information Act. So I haven't gone into those details, but you have to have a PIA manual, a Promotion of Access to Information Act manual. I don't know if any of you do, but if you've got that manual, it needs to dovetail with POPI. So as you sit here, you realize that not only one piece of legislation, but two pieces of legislation actually empower clients of yours or affected parties, stakeholders is a broader term, to actually get information from your business. You've got to have security safeguards. Now, I'm not a IT expert, but I do have colleagues and alliance partners who are IT experts. The days of going, well, you know, we have a server and we've got antivirus software on there and that should be enough is over. You have to make sure that if you are holding information in the cloud, or if you are if you've got information that is being held even on individual laptops or computers, that you have got sufficient security measures in place. And if you think about it, that includes making sure that you've got a alarm on your business premises so that you can do the best you can to make sure that if somebody breaks in to steal the computers that may have personal information on them, that you can at least say, well, this is what we did. We had armed response, we have burglar bars, we have whatever it is, to protect both the physical information or physical receptacles of information and the electronic information, which is, you know, if you've got something on Google Drive or you've got it on Office 365 or Gmail or whatever it is, you've got to make sure that you understand the security safeguards. And the more confidential and more personal the information is, the better your safeguards need to be. So for us as lawyers, our information is privileged. So we have a very high duty of care to make sure that our clients' information is kept safe and secure. Then you've got to have what's called data subject participation, which in my mind always sounds like some kind of party in a 1980s garage. But the truth of the matter is your data subject, your clients are allowed to ask you to confirm at no cost whether or not you hold any personal information on them. So I quite like this. So when you get those phone calls from Vodacom that you do, or whoever, sorry, I don't want to, or any service provider, who says to you, well, you know, I got this information, you have the right to say to them, well, how did you get that? And I didn't give it to you, therefore you have to delete it. Or if my firm, for example, phones a client and we say to them, okay, we sent the documents to you, we use this email address, they have the right to say, no, well, that email address has changed. You need to change that email address. You may no longer use it. And you've got to have an internal process for dealing with the confirmation, correction, and deletion of personal information by the subject. So you've got to make it clear, whether it's on your website or, and we'll come back to a POPI compliance manual, that makes it easy for clients to be able to say, okay, if I want my information to be deleted, and I'm allowed to have that information deleted because there's no legislation saying I must keep it, how do I go about doing that? Who do I phone? What email address do I use? So is there a POPI at Robyn Hay Attorneys email address that I must email something to say, please correct it, and what are the time periods, and if I'm not happy, who do I complain to? And something that I read in one of the articles on POPI, because you can imagine lawyers are reading and writing ridiculous amounts of information on this, is that you need to remember that the personal information is essentially on loan to you. You are a custodian of that information. You don't own that data subject's personal information to do with as you will. You are being asked to curate that information. And at any time, a data subject to obviously other legislation, can say, enough, I don't trust you with this information anymore. I don't want that information out there. Or I don't want other people to be able to get this information, therefore I'm deleting it. So if somebody gives you a sales call and once POPI is in play, and you say to them, well, where did you get this information? They have to tell you. And if you say to them, you have to delete this information, they must delete that information. So call centers, big insurance companies, any direct marketing companies that make use of direct marketing are going to have to completely overhaul their systems. You can imagine that that's quite a process and has quite a cost attached to it. So let's go straight to POPI and your sales and marketing. So we've gone through the Hateful Eight. And if you are in doubt, and if you go and see a lawyer and you say to them, I need to get my POPI manual in place, if they do not take you through the 8 conditions, then at least you can say to them, well, actually, either I'm not sure that you know what you're talking about, or these are the things that I want to make sure are covered so that I'm compliant. So how does POPI affect sales and marketing? So firstly, it doesn't mean that you can never, ever, 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 again, for as long as you live, have direct marketing campaigns by email, post, or SMS, or any other mechanism. But what it does mean is you can't only allow clients to opt out going forward. Clients have to be able to opt in. They must opt in. They can't just opt out. And they must also be given an opportunity to object to personal information being used for direct marketing. So they also have to opt in, and you have to give them an opportunity to say, under no circumstances may you use my personal information for direct marketing. So you need to inform your data subject before you add them to any kind of directory. So before you add them to your rich clients I like to market to bucket list, you need to actually tell them that they're going into this rich client bucket list. You actually have to tell them that. And it has a huge impact on automated decision making. So, you know, when you've got CRM information or CRM packages, or you've got mail merge packages, or anything where clients are automatically getting information because they fall into specific categories, you have to consider whether or not that is still compliant with POPI. You can't just keep doing things the way you have always done them, if that makes any sense. So what are the guidelines? So the guidelines for how POPI affects sales and marketing are found in section 23 and 24 of the Act. And essentially, if your data subject must be able to opt in as well as not as opt out. So I'm not going to lie to you, the policing of this is going to be tricky. But what you don't want is you do not want to be caught with your pants down. The reputational damage in the era where the right to be forgotten and the right to privacy are becoming more and more entrenched in the way our society thinks is just absolutely not a risk that I believe businesses should take. It's about doing the right thing. It's about doing the right thing with regards to actually using information that is proprietary to somebody else. You know, you've got to remember our reputations are attached to our identity. And for some people, they are more private than others. Some people are not as bothered by sales and marketing as other people. And I also need you to understand, if you have a look at section 107 of the Act, because if you're still reading by section 107, you really are the bravest business owner in the world. But essentially there, you can be imprisoned for a period not exceeding 10 years in certain circumstances, or 12 months in other circumstances, and subject to a fine as well. Now, you are more likely to be fined than going to prison, I'll be honest with you, but you don't need that additional cost in your business. Rather take your fine money, 50% of your fine money or 10% of your fine money, and actually get everything right up front. So when you are doing your sales and marketing process, you need to be upfront about the reason that you are requesting this information and what additional uses you may have. So I need to be able to say to my clients, look, I'm collecting this information so that I can provide legal services for you, to you, because I need this information to draft an agreement or to draft pleadings or whatever it is. I also am going to use this information, if you agree, to market my incredible innovative legal services to you, and or I'm going to use this information in order to bill you. And that needs to be spelled out. And the days of trying to trick people into agreeing to get your manky newsletter are over. You need to add value to clients, and you need to make sure that clients have agreed to be contacted by you. Spamming is truly an harassment and an invasion of privacy for many people. So you need to be upfront about the reasons you're collecting information. You need to use check boxes or opt-in buttons on emails and websites that are clear and allow your clients to see that they are agreeing to provide information and what information they're agreeing to provide and for what kind of marketing purposes. And then I'm a big fan of the cover your ass principle. My rule for all of my clients is have a system in place where you record how and when and what and for what purpose you got consent from the client. So if you get some revolting human being who has got too much time on their hands complaining about the fact that you sent them an email and you know that they opted in, you can actually show them that they opted in, and you can say, look, I'm terribly sorry you're upset. Our systems show that you opted in and this is what you agreed to. We are very happy to let you to opt you out. That's absolutely fine. But you don't want to be sidetracked in your business by hundreds of people having a nervous breakdown because you haven't told them in advance that you're going to be sending them your monthly newsletter. So people keep asking me this. South African business owners are astonishing to me. They are, on the one hand, extremely nervous because the economy is a difficult economy to operate in. And on the other hand, their attitude to compliance legislation is like, can I just ignore it? Now, I know that you may want to ignore this because it is not the most fun you can ever have in your life, but the answer is no. You can't ignore this. There are penalties, there's a criminal offense, and you also need time to put your processes in place. And there are costs to that. And remember, you're going to need to do several things to be compliant within the next 18 months. And if you start now, you're not going to be on the back foot. So how do I get started? Well, first thing you're going to do is you're going to go back to your office and you're going to draw straws for the appointment of an information officer. In all seriousness, what you're going to do is you're going to appoint an information officer, someone who's going to be responsible for this process. Then what I would immediately suggest you do is you start documenting your client onboarding process. So you sit down with the people on the ground and you say to them, okay, what do you use when a new client contacts you? Now, obviously, this is going to be different if you're running a retail store or whether you're doing services or whether you're doing online stores or online marketing. Every business is going to be different. So be very wary of people that sell you templates. Be very wary of people that tell you that they're POPI experts. You may be compliance experts, you may be an IT law expert, but POPI is very, very new. There's no expert there yet. So there are very limited templates that can actually just be sent out that you can adapt. So just be very careful of that. You can maybe, in a couple of years down the line, when everybody's kind of got to where the best practices are, then maybe things will be different. But right now, you have to sit down with your staff on the ground and you have to say, okay, what is my client onboarding process? What information do we collect from our clients? And is it all necessary? Do I really need to know a client's I don't know, home phone number or fax number? Do I really need to collect a fax number? Do I really need to ride my dinosaur to a fax machine in order to communicate with a client? Or can I actually scrap somebody's fax number because nobody has a fax number anymore? Then have a look at your IT security systems and research some best options. We've had a look at it. We've spoken to some of our alliance partners who've agreed to come in and help us with that. So whether you are using something like Irontree, whether you are using other service providers, you need to do that. It may be that you don't have to change anything, and it may be that your current service providers are enough, or it may be that you need to take some steps to make sure that your information is secure. Then you need to find a funny and intelligent lawyer, because I think most things are more palatable with a bit of humor, to look at your terms and conditions and your service level agreements, as well as the onboarding documentation, and make sure it's compliant. So they need to sit down with you and say, okay, well, let's have a look at how you collect this information. Let's have a look at what you are disclosing to your client with regards to where, when, how, and why you are collecting this information. Is this compliant? Is this tiny little checkbox in the smallest writing ever in the whole world in the footer of your document, is that really compliant? Do you think so? Possibly not. The same funny and intelligent lawyer needs to help you with preparing a POPI policy that complies with the Act and regulations. Now, the minute I write down the word policy, I actually hear my clients' brains just shut down. But the truth of the matter is, you have to train your staff. And you can only train your staff if you have a documented policy. Because when your staff or your employees or your operators are busy doing what they need to do, you want to be sure that if there's a breach for some reason, you are able to say, well, these are the policies that were in place. This breach happened despite the policy. And just remember that any breaches to the security of personal information that happens has to be reported both to the regulator and to the data subjects. And you don't want that embarrassment. You want to be able to say, we have this policy in place. There was a breach of this policy. I'm terribly sorry, Mrs. Smith. Your email address was accidentally used to, you were accidentally copied in an email you weren't supposed to get. You got to be able to do that. You need to check your existing marketing consent clauses to ensure that they comply with POPI and that they actually allow for the kind of marketing you do. Again, when you're dealing with new legislation like this, and I would say this is probably going to be, this caveat is going to probably be for the next 2 or 3 years, that you need to make sure that you have somebody who sits down with you and says, okay, well, what kind of marketing do you do? And so what information do you need? And what kinds of consent are you required to get? You have to create a privacy breach response plan, and you need to practice it. So if somebody accidentally, or if one of your computers is stolen and it's got your entire database on it, which I really hope is not the case, you need to be able to, you need to have a plan for that. You need to know what you're going to do. How are you going to notify people? Who are you going to notify? Where are you going to notify them? And how are you going to do that? I mean, it's not the world's easiest thing. So you really need to know this up front. Then you need to start training your staff and developing best practices. And when you start looking at all of this along together with the cut and thrust of running a business, you can see why a year or 18 months is not as long a time as you may think, because you have to actually practice the policies that you put in place. So in conclusion, my advice to business owners is always get the best advice you can afford, not the cheapest advice you can find. So speak to your accountants, speak to your lawyers, say to them, who is somebody that can actually help me with this? And if they say, okay, it's going to cost whatever it's going to cost, because every business will have a different solution, you need to weigh that up against the consequences of not being compliant. And don't use your uncle's cousin's boyfriend's daughter's sister who did 3 weeks of law school in 1972. They are not the right people to help you put a compliance manual together. There are consultants, there are lawyers, there are accountants, there are business advisors, there are people out there who can actually sit down and help you do it once and for all and do it properly. And use it as an exercise to spring clean your business. most firms, or a lot of firms, including ours, allow for you to do a big exercise like this over a period of time, and that you pay on over a period of time, so you can actually make sure that this is within your budget. You also need to speak to your HR people. Your HR people are the ones that know what information you have on your staff, because remember, your staff are data subjects. And what do you do when a staff member resigns? What is your policy then? We have we scan all our documentation when we do what we call dead file a matter, or have old records. Now we need to be ready to, how do we delete that information? How do we keep track of what information needs to be deleted? How do we put a timeline together to make sure that the right information is destroyed or deleted? And if you try and do compliance in a reactive way, you are always going to miss a trick. Compliance is proactive. Compliance is about future-proofing your business. It's not about scrambling like all hell when something goes wrong. Because in this day of social media and online marketing and all of the rest, the options, the possibility for mistakes are huge. And the speed with which unhappy customers can tell 2,000 people how unhappy they are is actually frightening. So let's not do that, because it's hard enough to run a business without having to worry about what's happening to your business's reputation in social media. So if you want to speak to me or have a cup of coffee or just chat about the weather and how little rain we're having in Cape Town, my contact details are on these slides, which you're going to get later. And I would be absolutely happy to have a conversation with you, clear up any questions over the phone. And if you feel that we can add value, I'd be more than happy to meet you. We've set aside some additional time in our pipeline for the month of April to make sure that we're able to assist anyone who is on this webinar. And we're looking at making sure that our clients are getting the best possible advice in a way that is affordable and is practical in the shortest period of time. So I would love to hear from you. I'd love to be the person to help you. And I know that Monique and her team of advisors are on standby to be able to help you to look at when it comes to your accounting information, what kind of measures you need to put in place. So that is my very exciting story. In fact, the whole story, end of slideshow, but I'll just leave it on contact details. There's never miss a marketing opportunity. And I don't know if there are any questions, Shane?
Okay, so thank you, Edmund, for this question. Hi, Robyn. Thanks for a great presentation. So much for business to take account of. What do you make of the current Facebook debacle in respect of data privacy? Regards, Edmund. Your comments on that?
Yeah. So the difficulty there. Okay, firstly, you're dealing with US legislation. My views on the current Facebook debacle with Cambridge Analytics or Analytica, I think it is. What they essentially did, those of you that don't know, is they used information from Facebook users for purposes that those users didn't know about. And I think that one of the biggest difficulties with that, again, is that is essentially you're not being upfront. And Facebook is bigger than the population of most countries in this world. And when you are running a platform of that magnitude, you have an obligation. To be upfront and to have a series of laws and policies, regulations and policies in place. And so I think it's absolutely right that people went mad. I mean, Mark Zuckerberg was forced to respond, and he was forced to deal with it. And I think that's right. Our information, our reputations are everything.
So now I've forgotten my question.
Hi, Robyn. How do you suggest that a one-man business approach POPI? That's from Arthur. Thank you, Arthur.
So Arthur, I think that is an excellent question. I have to say that one of the biggest difficulties you have as a business owner in South Africa is that there are literally hundreds of pieces of legislation that apply to you. So what I would do, it depends very much on what the nature of your business is. But what I would do, Arthur, is much like I've put on the slides, is to start with what processes do you use? And then look at those processes in line with the legislation, and over a period of time, over the next year or 18 months, that you just put a step-by-step process in place. And people talk about the cost of compliance, and the cost of compliance can be significant. But if your business is not complex, in the sense that you're not an affiliate of someone, and you're not sending information to the European Union on a regular basis, then to sit down with an attorney and or a consultant to actually go through what your options are and what the processes should be can just be a fairly straightforward process. So I don't, unfortunately, the excuse of, well, not that it's an excuse, but it's a legitimate concern. I've been a sole practitioner before, so I know exactly what you mean. The reasoning of, well, I'm a one-man band, I don't need to do this, unfortunately, isn't going to hold sway. But not every single business requires, 47 levels of security and 38,000 pages of policies. It can be a relatively simple process. And that's why I strongly suggest that you tailor-make those processes with somebody that knows what they're talking about.
Robyn, but I do also at the same time understand that this is new legislation and there is no case law, obviously, yet. So this might be quite a difficult question to answer at this early time. But I think it might be something that could be quite relevant and on a lot of business owners' minds. And that is, how would POPI affect credit bureaus, blacklisting of companies and CCs and individuals? I don't know if you have a view on this, or if this is something that... Yes, over to you, Robyn.
Oh, sorry, I do. I haven't looked into credit bureaus specifically, but again, that Arthur is an example of a very complex compliance process. When it comes to credit bureaus, you'd have to have a look at the National Credit Act, what the National Credit Act has to say about blacklisting, and it does have specific comments on that, as well as case law. And you also need to look at the purpose why you are collecting that information. And I do think that credit bureaus are going to have to relook at that information. At the moment, as you probably all know, if you're going to do it, you've got to consent to a credit check. So somebody can't just do a credit check. So you're going to have to look, the credit bureaus are going to have to look at the nature of that consent, and also the minimum amount of time that it is required to have that, for example, that blacklisting against your name, and also what the impact of that is going to be. So the debate is going to be, is it a breach of privacy, the fact that you have a judgment against you? And I would argue no, because your court process is a public process. Anyone can go and sit in a court and listen to a court process being held, and you don't have the right to privacy in a court unless it's a sexual offences act in a sexual offences matter in a criminal law context. So without having looked deeply into it, I think you're going to have to balance all those rights, including the right that people have to know the right to protect their businesses against the right of the individual. So it is going to be a balancing act. You've touched on a couple of things there. Again, what's going to be required is that your HR policies are going to have to be in compliance with the policies that are required in terms of POPI. So, information with regards to your with any potential disabilities and your health information is considered special personal information, and there's even a higher standard with regards to that. So if I just look at section 26 of the Act, so I've not quite memorized the Act word for word yet. So anything to do with your religious or philosophical beliefs, health or sex life is considered to be special personal information and can only be carried out, you can only process it with the express consent of the data subject. So Linda, in that kind of situation, and I don't want to take up everybody's time, but in that situation, what you're really looking at doing is sitting down with your HR policies and saying, to what extent do these conflict with POPI? How do we make them compliant? And what levels of consent do we need from our staff and from our interviewees and from our interns? You know, what kinds of consent do we need to get? And what do we do with that information once we've got it? So once we've done a reference check and we've got that information, what do we do with that information? So those are really serious questions that need to be considered within the context not only of labour legislation and employment equity legislation, but also within the context of personal information. And I think to go into more detail than that will require a discussion offline, if that's okay.